versus Green. Okay, hi, Ms. Davis, you're up.
Thank you, Your Honor. I was trying to do my timer, and of course, an advertisement came up on the app. May it please the court, Christine Davis, on behalf of the appellant, Nurse Garner. I'd like to reserve 5 minutes for rebuttal.
Sure.
So there's only one issue before this court, and that's whether Mr. Green would not have died had Nurse Garner called Dr. Quato Lithgow on the morning of October 17th when he experienced shortness of breath that was resolved upon lifting up the head of the bed. The plaintiffs presented one expert witness on causation, and that was Dr. Harward. Dr. Harward's conclusions with respect to Nurse Garner require the court to accept a number of assumptions that aren't grounded in the actual facts established at trial. The first is that had Nurse Garner called Dr. Quato Lithgow on the morning of October 17th, that Dr. Quato Lithgow would have immediately transferred Mr. Green to the emergency room. The actual facts show that she would not have done that. On October 16th, the day before, when Mr. Green complained of shortness of breath with pain upon inhalation, Dr. Lithgow testified that she did not believe he had a pulmonary embolism. She unequivocally did not believe he had that. She didn't test for it to confirm or deny it. And she just ordered that he be monitored. The next day, on October 17th, when Mr. Green experienced shortness of breath without pain upon inhalation, one would have to assume that notwithstanding Dr. Quato Lithgow's prior conclusion, she would have completely reversed course and immediately sent him to the emergency room without coming in and evaluating him and without conducting any further tests. She would have just sent him there. The facts just simply do not support that. And as we know, an expert's conclusions have to be grounded in the actual facts of the case. They can't be based on assumptions that the record doesn't support. So the second one is that even if you accept the conclusion,
but isn't your argument essentially that they would have acted in the same way they acted previously, even though we know he had a DVT and there were ongoing issues relating to it, that they would have ignored the repetition of the shortness of breath?
So what the record shows that that's exactly what she did. She didn't believe his shortness of breath. There are about 6 or 7 symptoms of a pulmonary embolism that we set out in our brief. The only one Mr. Green had was shortness of breath. On October 16th.
But there was evidence that is a significant indication of a shifting embolism, or that there were particles that had now shifted.
In a patient with DVT.
Correct. There was evidence.
DVT was pretty extensive at this point.
That's right. And the evidence was that Dr. Quato Lithgow, despite those symptoms, did not believe he had a pulmonary embolism. And so there you would have to jump to a conclusion that the next day, with less severe symptoms that had been resolved, that she would have done something else. And that's simply not supported by the actual facts. So the second assumption that you would have to make is that Dr. Harward said it all depends on what time Mr. Green would have gotten to the emergency room on the morning of October 17th, and that he would have been aggressively treated when he got there. And that was dependent on, one of the things he said is that was dependent upon the staff at the emergency room getting the right story. So what the evidence showed, the story that they would have gotten at the emergency room is that he had symptoms of shortness of breath over the prior few days, but he had no active symptoms of a pulmonary embolism at that time because they had quickly resolved. And the evidence was that typically with a pulmonary embolism, you don't have symptoms that ebb and flow with shortness of breath. They're typically persistent. They don't just go away like they do here. And so the emergency room, I'm sorry.
Go ahead.
The story that would have been given to the emergency room would have been that he had no active symptoms of pulmonary embolism, that he had been properly anticoagulated with Lovenox, because no one at that point knew that he had not been properly anticoagulated. And then they would have known that the shortness of breath typically persists. So that's the second one that's not supported by the evidence. And the third is that Dr. Harward's testimony, his opinions were contingent on all of these things happening at the emergency room with perfect timing. So he would have to get to the emergency room immediately. And we know from the record that on October 8th, when he was sent to the emergency room with the DVT the first time, it took them 12 hours to send him to the emergency room.
Let's come back to Ms. Davis. Dr. Harwood testified that, is my understanding what his testimony was, is that had the patient been taken to the hospital and there was a reasonably aggressive doctor there, he likely would have survived.
That's correct.
And you can't, I mean, there's nothing that undermines that testimony, correct?
Well, what undermines that testimony, or what makes that testimony not grounded in the facts of the case, or requires it to be dependent on assumptions that aren't supported by the record, is that he would have to get to the emergency room, and everybody would have had to, he would see a number of specialists. They all would have.
On the other hand, we can't know what would have happened because your client didn't make the call.
That's correct.
So none of the doctors had the opportunity to make those decisions.
That's correct.
Didn't Dr. Quato Lithgow testify that she absolutely would have wanted to know? She testified that she would have wanted to be notified of these symptoms when they happened, because that was a significant change. And because she knew these were potential signs of a pulmonary embolism, and that she would have, and she kind of gave two answers here. She would have either ordered more tests or called 911, but 911 would have been the quickest way to take care of him.
That's right. So we get to the Saunders part of this argument, where which is sort of a big part of the plaintiff's argument, that you can rely on a reasonably prudent physician, what a reasonably prudent physician would have done. So we know the actual facts of this case are that it's very unlikely, if you look at her facts, regardless of what she said she would have liked to have known, that she would have actually done that. Those were facts, as opposed to her subsequent testimony as to what she would have done.
But aren't you arguing basically essentially making a jury argument here, as opposed to, us looking at this cold record?
Right. I understand why you would ask that, but I don't think so, because the critical point here is the law that's established that an expert's testimony has to be grounded in facts, and the actual facts in the case, not on what a perfect world scenario would be. So in Saunders, that the plaintiff relies on, the Supreme Court said a subsequent treating physician can't come in and say, I wouldn't have changed my mind, and then that defeat the plaintiff's expert's testimony of what would have happened. So Dr. Quato couldn't have come in and said, I would have emergently treated, sent him to the emergency room, and that's all, and that would be enough to defeat any other testimony. But what it doesn't allow, and what the plaintiffs, I think, have taken Saunders in those cases too far, is a piling on of reasonably prudent physicians. So you look at what you have to go to, what would have happened when he got to the emergency room with this. And Dr. Harward repeatedly admitted that what he was saying was speculative, and he didn't know the answers about timing. He didn't know when things would have come in, and that she would have had to, Mr. Green would have seen a triage nurse, an emergency room doctor, and then hopefully they would have called an interventional radiologist or a vascular surgeon. and then he would have had to see a radiology tech to get the procedure done and the testing read, and then he would have had to have the filter placed in. That's stacking on a reasonably prudent physician on top of a reasonably prudent physician on top of a reasonably prudent physician when there's no evidence that that would have actually happened. And the only evidence is that Dr. Harward said he had no idea, and that was all speculative as to when that would have occurred.
Well,
So
he was not a fact witness, was he? He was an expert witness on causation, correct?
That's correct, yes. So you have to take what he's saying and look at it in the context of the actual facts of this case. And so what we submit is that his conclusions are require too many assumptions. You're having to jump through too many hoops to get to how to get to the point where he says his life would have been saved just because Nurse Garner didn't call Dr. Quato Lithgow. We're not talking about Dr. Quato Lithgow's own negligence from October 16th or Nurse Karan's negligence from the very beginning. It's had Nurse Garner called on that morning. All of these things would have been different, and they all would have been done in perfect timing. And
one of the factors that, at least to me, stood out is the fact that he had had repeated episodes of shortness of breath. And doesn't that reasonably lead to the testimony that was given that it is likely or possibly a deteriorating situation, and because it's a repetition, we need to now act more aggressively than we might have acted earlier?
It does. I agree with that. But the actual facts, I think, that were established as opposed to assuming what would have happened is that she absolutely didn't believe, Dr. Quato Lithgow didn't believe he had a pulmonary embolism. So how would she have believed one the next day when his symptoms were much less severe and they resolved themselves quickly? So you kind of have to assume, you take the facts that we actually have, but then you have to just assume that everyone would have acted perfectly the next day.
But aren't you essentially arguing that her testimony that she would have called 911 and she would have moved more aggressively, isn't that a credibility determination?
That's actually irrelevant, or it's irrelevant under the Saunders case as to what she actually said she would have done, because that's so in Saunders, they come in, the doctor comes in and says, the plaintiff presents expert testimony of a breach of the standard of care and why that caused the injury. And then the actual treater came in and said, no, I wouldn't have done that. And they tried to use that to defeat the plaintiff's testimony. And so you can't do that. But you look at, so what Quato Lithgow actually said is under Saunders is not the critical inquiry here. You look at what's actually happened, what the actual facts established.
But that by itself may not be determinative. But when you have experts saying this is what would happen if a reasonably prudent physician, reasonably prudent nurse, reasonably prudent triage physician all would have done in light of the history with this patient, that is admissible, right?
Yes, that's admissible. But
so let's go back to my question then. Isn't that now a credibility determination for the jury? Would these reasonable things have happened, or that sounds too far-fetched in light of what happened in the past?
Well, I think that you have to look at what is actual facts and what are assumptions that are not supported by the record that the expert is simply concluding. And that's that all of these things would have happened in perfect order with perfect history and perfect timing.
Well, aren't you basically arguing, Ms. Davis, essentially that, none of this, we can't know exactly what would have happened because Nurse Garner did not make the call. So essentially you're arguing that since you don't seem to be challenging the evidence that fell below her standard of care. So what you're arguing is that if her actions fell below the standard of care such that she didn't make the call, we can never find her liable because we don't know what would have happened had she the standard of care.
Under the facts of this case, because when you look at the facts that were established by the evidence, you really have to stack on all of these other things. So let me give you an example. That's
almost always the case in med mal, is it not?
It is. But what you have to, under these particular facts, what you have to assume, there would be no way of disproving causation here, because once you have a breach of the standard of care, then you have to assume that everyone was going to act perfectly after that. And that's assumptions. We would never be able to defeat that, because you'd say, well, that was a reasonably prudent physician, and that would be a reasonably prudent physician. So everyone would act perfectly. And Dr. Harward even admitted that was speculative as far as timing, what they would have done. And so at some point, there's got to be a line drawn and showing causation, where you're not just saying that there's a breach of the standard of care, so you're automatically proving causation because everyone would have acted perfectly. And it's not because she didn't make that call. You just have to assume that, despite the facts that there's a timing issue that makes this unlikely, that Dr. Harward admitted there was a timing issue, that it may or may not have been done during that time, and that he didn't have active symptoms of a pulmonary embolism. They had resolved, and all of these things that were actually established by the facts. You just have to put them by the wayside and assume that everyone acts perfectly afterwards. That substantially changes what a plaintiff has to prove causation. And when you look at the causation cases, so for example, the plaintiff cited Hancock and Aragon, and both of those cases.
Let me just interject, Ms. Davis, that you are down to 5 minutes. So
I see that. Thank you, Your Honor. I'll just finish this one thought and take whatever I have left. So, and if you compare the Hancock and Aragon cases that the plaintiff cites, in those cases, you had actual evidence of that. For Aragon, for example, that had the standard of care not been breached by the internist, a pre-treatment plan would have happened, and he would have likely not died, probably not died. And the same for Hancock. Here you have to fill in a whole bunch of other holes that aren't filled in to get to that same conclusion. It's not just one step and then you get to the next step. You have to go, here's your breach of standard of care, and then assume a bunch of things that aren't supported by the record to get to that. So with that, I'll reserve the remainder.
Okay, you've got 4 minutes left, so just keep that in mind. All right, Mr. Jason.
Good morning, everyone. Chris Jason on behalf of the appellee, Linda Green, the personal representative of the estate of her husband, Robert Green. The gist of the argument by the appellant in this case is, because Dr. Quato Lithgow committed malpractice on October 16th, she more likely than not would have committed malpractice on October 17th as well. And that's not the standard under which the conduct of these healthcare professionals is derived. It's important to know that on the 16th, when Mr. Green was scheduled for discharge and had his first incident of shortness of breath with pain upon inhalation, she ordered an X-ray, which was clear, proved there wasn't some kind of pneumonia causing the shortness of breath or the pain in the chest. But she also ordered close monitoring of Mr. Green, breathing treatments, O2 stats, which implies that she was going to continue observing him. Now, our experts felt that was below the standard of care, but even she at the time was concerned about it enough not to discharge him to order these other treatments. And when Nurse Garner came on duty the afternoon of the 16th, she knew he had an extensive DVT that went from his ankle up through his hip. She knew he was on anticoagulants. She knew that he was in 8 out of 10 horrible pain and on both Dilaudid and hydromorphone for pain relief at the time. When she noticed that he had another episode of shortness of breath and an inability to speak more than 4 to 5 words, that was a change in condition that the doctor needed to know about. The nursing expert, another doctor, our expert internal medicine doctor, all testified to that, and they're not disputing that it was below the standard of care not to call the doctor. The issue is what would have happened, what should have happened when she called the doctor. The testimony of our internal medicine doctor, Dr. Yaffe, was unequivocally that had Nurse Garner called the internist with this constellation of symptoms, a repeat of shortness of breath, an inability to speak more than 4 or 5 words, in a patient with a known extensive DVT on anticoagulation, the standard of care required emergent transfer to the hospital for a test. And the reason that's important is the only test left to do would be a CT angiogram, which they could not do at this facility. The only way to get that done was send him to the hospital. So we know from prior experience back on the 8th, when he was first diagnosed with the DVT, they called emergently to transfer him to the hospital. The hospital was the same one he had his orthopedic surgery in originally. It's less than a mile down the street from Concordia. And on October the 8th, there was evidence in the chart, the transfer records. It took 28 minutes from the call to EMS to actually depositing him in the emergency department. And he was home before midnight, less than 4 hours later, after he was evaluated and given the proper prescription for Lovenox from the emergency doctor. So there's evidence in there that what should have happened was an emergent transfer. That's undisputed. There's no expert testimony to the contrary. They cross-examined Dr. Yaffe about it. They cross-examined Dr. Harward about it, but that was what the standard of care required. Dr. Yaffe's testimony has to be considered along with Dr. Harward on the causation issue about what Dr. Quato Lithgow should have done. And Dr. Quato Lithgow supported Dr. Yaffe's testimony by saying she would have loved to have known because she would have done something, either ordered more tests or sent them emergently. And as you said, Judge Northcutt, she was a little wishy-washy about exactly what it would have been on, but she said, I would have done something. And the standard of care required her to send him back to the hospital, which was a half hour away. We also presented the testimony from an emergency room physician, Dr. Yagminas, in our case, who testified that the standard of care with an extensive DVT like this in a person with symptoms of a pulmonary embolism would be to immediately order a consult from a vascular surgeon or an interventional radiologist, either one, because those are the people that treat these kinds of problems. Dr. Harward testified typically the on-call vascular surgeon will be required to respond within 30 minutes to an hour. He testified that once he got there, he would have ordered a reasonably careful vascular surgeon would have ordered a CTA. The CTA would have shown these prior pulmonary embolisms that he had on the 16th early and on the 17th when Nurse Garner was evaluating him. And as you indicated, Judge Silberman, these are individual pulmonary embolists. They start small and they come up and they cause problems, but they can resolve themselves and go away. But once you start propagating these clots coming off and they're traveling up into the lungs and the heart, that's a real problem. But people can have multiple ones and they can have them as a series of incidents. And it was an undisputed testimony of Dr. Harwood that he had pulmonary embolism both on the 16th and the morning of the 17th when Nurse Garner was seeing him. So Dr. Harwood testified what would happen once the CTA, which he believed more likely than not would show the prior pulmonary embolisms. He says he bought an emergent trip to the lab to insert a greenfield filter. The greenfield filter, according to Dr. Harwood, was as close to 100% effective to prevent the lethal and deadly type of pulmonary embolus as there is. It doesn't stop the embolism from happening, but it catches it in the vena cava and stops it from killing you until they can remove the clot. So the actual procedure itself to insert the vena cava filter, Dr. Harwood said, takes about 5 minutes once you're in the lab. So and he testified unequivocally, had that happened, he would have survived. And there was another expert, Dr. Naslund, another defendant's vascular surgeon, who agreed that if he'd gotten to the hospital that morning, he would have survived because they would have determined he had a pulmonary embolism, they would have inserted a filter, and he would have lived. It's important to recognize that she claims she saw him between 5 and 6 a.m. We don't know the exact time because she failed to put anything in the chart at the time. She didn't chart contemporaneously of that evaluation until 8:30 the next night after Mr. Green had been discharged from the facility and frankly, after he had passed away. The nurse didn't know that at the time, but when she inserted this late note in the chart, she was estimating that it was between 5 and 6. Taking her at her word that it happened approximately 6 o'clock, Mr. Green didn't die for 8 hours later. He died in his driveway when his wife drove him home. He'd never got in the house. He was in the driveway getting out of the car when he had the fatal pulmonary embolism. EMS service was called at 1:56 p.m. So there were 8 hours between the time of Nurse Garner's negligence and the time he suffered his fatal event. Dr. Harward testified that if any time prior to that fatal event he had gotten to the point where they inserted a greenfield filter, that the greenfield filter would have saved his life and he would not have died from this massive saddle embolism that ultimately killed him. So we have not only the testimony of Dr. Harwood, but the testimony of Dr. Yaffe, the testimony of Dr. Yagminas, the testimony of Dr. Naslin, all of which support a jury's finding that Nurse Garner's actions caused or contributed to the death of Mr. Green. The jury apportioned fault 70% to Nurse Coran, 15% to Dr. Quato, and 15% to Nurse Garner. And there was ample evidence for them to do that. There was no evidence presented to the contrary. There were no experts, no doctors, no witnesses who testified, hey, look, there just wasn't enough time in that 8 hours to get him to a hospital and get him treated. There was no one that testified to that. We don't believe that the standard in Gooding that we show that the negligence probably caused or contributed to the death requires us to get down to the level of granularity that the Nurse Garner's counsel would like us to do.
Essentially, I guess one way to look at it is the argument is that you should have disproved an intervening cause.
Correct. We would have had to prove that the telephone was working, that our answering service answered, that she would have received the call from the answering service, and on and on and on, and have to disprove all these potentialities, which, our expert in his experience, including experience at Shands Hospital for 6 or 7 years in vascular surgery, as to how hospitals work, how vascular surgeons work, and what would have occurred. And it was his bottom line opinion that had she called the doctor, there was plenty of time to treat him, get him to the hospital, evaluate him, and treat him in time to stop this fatal pulmonary embolism. What they're essentially asking you to do is to be a seventh juror to reevaluate the evidence and testimony and the credibility of all of these expert witnesses, and to overrule what the jury determined. We believe we met the burden of proof at trial, that there was a reasonable basis for the jury's conclusion that more likely than not, Nurse Garner's breach of the standard of care was a contributing cause to Mr. Green's death. And we would request that the court affirm the verdict.
Thank you, Mr. Jason. Okay, Ms. Davis, you're up for rebuttal.
So I think the one thing or the overarching thing that we're not trying to say is, or that we are trying to say is that you have to look at what actual facts occurred. Dr. Harwood said that when he would have gotten to the emergency room, or when Mr. Green would have gotten to the emergency room, was entirely speculative. You don't know when things were going to be done and when they would have been done quickly. The timing that Mr. Jason points out is a time that the actual procedure has to be done. It doesn't include all the other timing and all the other specialists that he has to see in the process. And we all know that you don't go to a hospital and everything just goes along perfectly. So the point is that when we know that there was evidence to create a disputed issue of fact as to whether Nurse Garner breached the standard of care and that she should have called Dr. Quato Lithgow that morning. But the actual facts belie the conclusion that all of these things would have happened in perfect order and would have been okay. That's all based on assumptions, not in the facts. And causation that just stretches causation too far, we submit, because otherwise you would say, once you prove a breach of the standard of care, you would get to assume, despite what the actual facts are, that everything would have happened perfectly based on nothing but the conclusion of an expert that's not grounded on the facts of the case. And so we think that stretches causation too far. And in this case, it's stacking on too many reasonably prudent providers, which is contrary to what Saunders held. It stretches Saunders too far, and that it simply just does not prove causation with respect to Nurse Garner. So we would ask for reverse as to Nurse Garner.
Okay, thank you, Ms. Davis. All right, the two of you need to leave our virtual courtroom, and the way you do that is you click the button on your Zoom screen marked, interestingly enough, leave, and you will disappear. We'll keep you in mind, though.
Thank you, Your Honors.
Thank you. All right, our next case on the docket, our last one, is Coleman versus Security First Insurance Company.